afternoon.
Can y'all hear me?
Yes.
Yes.
Oh, nice to see you all today. All right. Just trying to get a full view here. Full screen, there we go. All right. Good afternoon, everybody. I'm Judge Nicola. Natalia, can you hear me? Are we good today?
Yes.
All right, wonderful. Having a little bit of trouble with connection, but hopefully this afternoon will be good. All right, so I have two cases that are going this afternoon. Ceramic Installation versus Blue Water and Feldman versus United Specialty Insurance. Are all the parties here on either case?
Well,
All of the parties. Yeah, we're here on the Feldman case. It's my client's motion to dismiss the complaint. I don't know that any other attorneys will be joining us today.
And the plaintiffs are
afternoon.
here on that also. Sorry, Your Honor.
Good
You're
afternoon.
here on this one too, ma'am? You're here
Yes.
on the Feldman
We're
and Simon? Okay.
Yes.
And Mr. Snyder, who are you here for today?
Good afternoon, Your Honor. Neil Snyder on behalf of defendants Jose Martinez and Osnat
Mendelsohn.
Mendelsohn.
Okay, so you're all here on the Feldman case. Everybody that's here in the room right now is here on Feldman versus United Specialty. Is that right?
Yes.
Yes.
Okay. So this is 20 SC 2834. And so Mr. Feldman is the plaintiff. And then we've got 5 defendants: United Specialty Insurance, Alpha Omega Insurance, Jose Martinez, Osnat Mendelsohn, and Sanchez Enterprise Group. Okay, so let's start. Mr. Zolad, who are you here for today, sir?
I represent Alpha Omega Insurance of Naples.
Okay. And Ruth's iPad, who are you guys, please?
We're David Feldman and Ruth Simon, who are the plaintiffs in the case.
Okay, thank you. Okay, and Mr. Snyder, who are you representing, sir?
Hey, good afternoon again, Your Honor. Neil Snyder on behalf of Jose Martinez and Osnat Mendelsohn.
And okay. So it looks like we have a few other defendants that, let's see, I got a letter from Henry Johnson. It looks like he represents Sanchez Enterprise Group.
That's correct, Your Honor.
There was a letter that was sent to my office that says, enclosed, please find proposed order on plaintiff's motion to vacate order of December 10, 2020 and restore case to small claims docket. Has everybody had the chance to review that order?
Yes.
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 And is everyone in agreement with that?
Yes.
Yes.
Okay, perfect. I just wasn't sure if everyone had seen it and agreed to it. I wanted to make sure before I signed it, so I am signing it. All right. All right, so we're here today on the motion to dismiss. This is the plaintiff's motion, or no, it's not the plaintiff's motion. This is Mr. Zola, this is your motion, correct?
Correct.
Okay, and I just need to pull it up again. And if I remember correctly, I thought the last time that we were here in court, there was an argument that your client was an improper party to this. There was actually, that yours actually was the insurance agent, if I remember correctly, and the plaintiffs were saying, okay, well, maybe we have the wrong party, but can they please tell us who it is that we should be suing?
Well, I'll clarify that. Yes, my client is the insurance agent for Sanchez Enterprise Group. I believe what you're referring to is that they may have included the incorrect insurance company as a defendant, and that may be what the issue you're referring to. And Mr. Feldman or Ms. Simon may be able to weigh in on that clarification.
Yes. We'll get to it. Will be covered a little bit in the argument, but basically what happened is that the certificate of insurance that was provided to the Solomar, it had the correct agent on it, which is now the defendant, Alpha Omega, but it also had the name of the wrong, apparently the wrong insurance company. And so when we sued United Specialty Insurance Company, they eventually got back to us and says, I don't know what's going on here. We don't have a policy covering the Sanchez Enterprises. And so what happened last time is I said that we would like to dismiss United Specialties if we got assurances that they are in fact the wrong insurance company. However, we don't want to dismiss the case against Alpha Omega.
No, Alpha Omega is the correct party.
And Mr. Zola, you're saying Alpha Omega is not the correct party.
Well, Your Honor, I'm moving to dismiss based on the pleadings and the failure to assert a claim against my client. And if you'd like, I could get into my motion. Okay. As you're probably aware, I'll just give you a brief overview of the case. It's a water intrusion case into the plaintiff's property. My client is the insurance agent for Sanchez Enterprise Group, the contractor who performed some work in Mr. Snyder's client's apartment unit and who allegedly caused a water intrusion into the plaintiff's unit. My client had no relationship, no role with the plaintiffs. She simply, or the entity simply procured a policy for Sanchez Enterprise Group as requested. The certificate of insurance that's attached to the statement of claim is from May 2019. I believe this incident occurred in November. It's unclear whether that certificate of insurance was prepared for this specific work that was done. The statement of claim itself, it's not clear what specific claim or legal argument plaintiffs are making against Alpha Omega. From what I gather in reviewing the statement of claim, and specifically I'll cite to a portion of the statement of claim, it says defendants AIX and the agent, referring to my client, were paid for this policy to enable Sanchez to perform the work by fraudulently inducing Solimar to allow Sanchez to perform the work in the Solimar. From that portion of the statement of claim, it appears that the plaintiffs may be trying to assert a fraud claim against my client. As you're aware, you need 4 elements that you have to meet to prove this claim, specifically that the defendant made a false statement of fact to the plaintiff. The defendant knew the statement of fact was false when made. The statement was made to induce the plaintiff to rely on it, and the plaintiff was damaged as a result of its justifiable reliance on the statement. I could get to each and every one of those elements, but essentially, they haven't alleged the facts necessary to support that claim. So I don't think that a fraud claim could stand, and that should be dismissed if that's what they're asserting. The only other claim that I can gather may be trying to be alleged by the plaintiffs is a civil conspiracy claim against my client. And again, I just don't know. I don't know what's being alleged. If Your Honor would like them to clarify or amend their pleadings to reflect the specific allegation or specific claim that's being made against the insurance agent, I would request that. Otherwise, I think that the statement of claim as alleged against my client, Alpha Omega, should be dismissed.
I read that. I just want to take a look at the complaint real quick again. Plaintiffs, what's your response to the argument, please?
Okay, our response is that, first, I want to put the case into perspective because it's been sort of blown out of proportion here by various defendants.
Well,
And that is-
understand, sir, that we're only here to address the pleadings today and whether the pleadings are sufficient to state a claim against the defendant. So.
Okay, but but the purpose was to put this into context, but I'll leave it out of context and say that what happened here is in order for a contractor to perform work at the Solimar, and by the way, the Solimar is specifically on the certificate of insurance, so it was done for this job. In order to perform work at the Solimar, they have to provide evidence of general liability insurance so that if the Solimar condominium incurs damage or any of the individual unit owners in the building incurred damage, that there will be funds available to pay the people for the damages that were incurred. So what happened here is that there was a flood. It flowed right down the building and going through every single apartment down to ours. It was found to be in the unit of the Mendelsohn Martinez, where the defendant Sanchez Enterprises was doing the work. And when we put in a claim with the insurance company, we were advised that there was no recovery for the claim, not because the claim wasn't caused by Sanchez Enterprises. They didn't address that. What they did say is that this general liability policy is a very unusual policy. It costs $600, which is practically nothing. And what it doesn't cover the first, the retention amount, which we believe is $25,000, but it could be a different amount. And also it doesn't cover water that harms a third party. So if we prevail against the Sanchez Enterprises, that the water released from that apartment that went to our apartment is not covered by this policy, because among the many exclusions in this policy is an exclusion against third-party water damage. And by the way, there are many, many more exclusions. So what happened is that when Solimar asked for the certificate of insurance, and they don't ask for the entire insurance policy, they got a standard certificate of insurance that said you have liability insurance, not that you had liability insurance, but it's got so many holes in it that it's really no insurance at all. So the policy was procured through this agent. So the agent was well aware that this was far less than anything close to an insurance policy. It made a representation to the Solimar, not only to the Solimar, but for our benefit too, because it's clear that, from the contractor rules and from the other documents at the Solimar, that this benefit is that they're doing this not only for themselves, but they're doing it for the tenants. And as a result, and that was relied upon, because without this certificate, the Solimar would not have allowed the Sanchez Enterprises to do any work in the building. And we were damaged thereby, and we weren't able to recover. I believe that if this was proper insurance, this place would be over already, and it would have been paid. I think that we made out all of the 4 elements for fraud, but in any event, we made out the elements for detrimental reliance, which would have been in this case, even though they didn't speak to us, the Solimar is reviewing the certificate insurance on our behalf, or for a misrepresentation, even if it wasn't actual fraud, it was just a misrepresentation. But clearly they knew what they were doing. They gave a policy which they had to know based upon the fact that this is a unique policy. Even the insurance company that issued the policy said it. I understand that, it's possible that our complaint is not what a Florida attorney would have put together, but we filed this in small claims court, which was supposed to have a concise statement of the claim. There's more than enough information in this complaint to allow Alpha Omega Insurance to understand that what we're claiming is that they shouldn't have given a statement to the Solimar that said that this person had insurance that would protect general liability, when in fact it didn't.
Okay. Well, here's my quandary. I mean, I think from what I gather from the plaintiffs, we have the Sanchez Enterprise Group goes to Alpha Omega and says, I need insurance to cover this job at the Solimar condominium development, and probably goes in and buys the cheapest policy that he can get, which is $600. And it has all these exclusions for damages and liability, et cetera, et cetera. But the only thing the condo complex asks for is just a certificate that he's got insurance, which they provide. So from where I'm sitting right now, I think it's a stretch to be able to suggest that Alpha Omega conspired with Sanchez in order to provide deficient condominium insurance to Solimar and thereby cause damage to all its tenants when the water damage happened. However, I am going to grant the motion to dismiss
Your Honor, can I
without
respond,
prejudice, without prejudice, which means this. I have given you folks the opportunity to conduct discovery. If you find through the discovery that you have sufficient proof that the Alpha Omega Insurance Group did conspire with Sanchez Enterprises Group to fraudulently and intentionally deceive the Solimar Condominium Association, then I will allow you to file an amended petition, which brings them back into this litigation. But I think the bare supposition that because the insurance certificate was given to the condominium association based on a policy that was purchased by Sanchez, that equates to fraud, at least for today's purposes, is a stretch.
Your Honor,
yes, sir.
I'm sorry. I do want to correct one thing that you said, is that they didn't just say we want an insurance policy or proof of an insurance policy. It is proof of a general liability policy. And a general liability policy covers third-party liabilities. And when you have a policy that doesn't do that because it has so many exclusions, that it's just not a general liability policy. I am quite confident that if you go to the management of the Solimar and say, is this what you, when you say a general liability insurance, do you think it has third-party coverage? And what's the most important thing of third-party coverage? I'm fairly confident they will say water damage. Mm-hmm. And so I don't think that the Solimar said, give us a policy. It said, give a liability policy. The certificate said they had general liability coverage. They didn't.
Also, we didn't just allege there was a conspiracy. We alleged that they did this negligently, that they did this improperly, that we have a contract claim against them because they issued this certificate of insurance when in fact there is no insurance.
You do not have a contract claim against Alpha Omega Insurance because you are not in privity of contract with them. The person that's in privity of contract with them is the Sanchez Enterprise Group. And the person or the company that owed an obligation to your condominium association to make sure that sufficient insurance was procured was the Sanchez Enterprise Group. So really the answers to whether or not you can bring in Alpha Omega Insurance of Naples, it lies truly within the individuals that procured that insurance from the Sanchez Enterprise Group. And you may question that individual, as I had indicated in my order allowing discovery, and that person may say to you, you know what? I talked with so-and-so at Mr. Zolot's client's insurance company, and I said to them, I want you to prepare documents that will let the condominium think that I have sufficient insurance, but wink, wink, I don't have sufficient insurance. You get that information, I'll allow you to amend your complaint and bring them back in. But just the allegation that the Sanchez Enterprise Group went to Alpha Omega and asked for insurance and they gave him exactly what he asked for without more is not a claim against Alpha Omega. I'm sorry, under the law, it is not.
Your Honor, I disagree with you, but let me explain why. If I had a car insurance policy and I went and I had someone give me a little card so I could register my car with insurance on it, and the insurance said I had general liability coverage, but in fact, the policy didn't cover the first $25,000 of any injury, and it also didn't cover people driving on interstate highways. It only covered small county roads. If somebody was injured by that claim, if I followed the rationale that was just given to me, that would say that the person who was injured by that car would have no ability to sue the insurance company because, well, the person asked for an insurance policy that didn't cover interstate travel. They just asked for county road travel. And I guess that, somehow someone should have figured that out. But the fact that they were able to license their car based upon that fact, to me, that's the same thing. It's just a different accident. If somebody had in order to drive a car, you need a full insurance policy. And in order to work on a Solomar, you need a general liability policy.
And following that logic to its conclusion, when I look at my automobile insurance card doesn't tell me whether I have $100,000 in coverage or $1 million in coverage. So somebody gets into a car accident where I clip them, blowing through a red light, and I cause them $1 million in damages. They say, you've only got a $100,000 policy, you don't have enough insurance. Then they go and sue my insurance company because they say that my insurance company didn't give me $1 million in insurance, so they conspired with me to defraud the person that I just hit.
Well, except
that I have with it is, unless you can prove that the Alpha Omega Insurance Group knew exactly what was required by Solomar Condominium and that they intentionally misled them through their collaboration with Sanchez, I'm not going to allow it. You guys get that information to show that they were conspiring with Sanchez. They knew your condominium requirements and they intentionally disregarded it and sent over a piece of paper that was fraudulent. I'll allow it all day long. But simply the fact that Sanchez went and procured this policy that was insufficient under your condominium rules is not sufficient for me to find fraud. I just can't make that stretch.
Your Honor, they did not have $1 million in a policy. And there's actually a case, it's not a local case, but there's a case in Texas in federal court where they looked at this very same issue with a retention. And they said somebody who has a policy with a gigantic retention doesn't have a $1 million policy. And our contract required $1 million policy. And I agree. If they had incurred $2 million worth of damages, I wouldn't come back and say, well, they already spent $1 million and mine was $1.020 million. I would say I would not hold Alpha Omega responsible. Just like with the car insurance, if the state requires $100,000 and they incur $1 million worth of damage, I would have nothing against the insurance company because they gave a policy with the numbers that were set out. In this case, number one, they didn't give a policy with the numbers set out because of the retention. Because in fact, there was no insurance because I don't think Mr. Sanchez can afford to pay any retention. Second of all, in this case, there's a difference between the limit of liability, which is set by law in driving, and I'm not saying that you have to have an endless amount. But if you had a policy that didn't cover something that comes day to day, for even that limited amount of $30,000 or $50,000, whatever the policy was, then I think that an agent would have a problem. If the law required $50,000 worth of coverage and they gave $10,000, I would say that's wrong and they should be held responsible. And I hope that you do too.
The problem is the person who's responsible for procuring the policy with sufficient liability is Sanchez. They were the ones who were responsible for understanding what your condominium rules require, and they were the ones that were responsible for conveying that to their agent. Unless you can provide to me information that Sanchez knew what your condominium required and went to its agent and said, hey, Solomar requires X amount of dollars without exclusions, but I want you to write me a policy for much less and make it look like I have much more, I'm not going to allow the claim against Alpha Omega. You may be able to find that information, sir, but you do not have that today. And it's a big stretch for me to make that leap. I'm not making it unless you can provide me with more, because right now we don't have more. Mr. Zolat, I'll allow you to respond.
I just wanted to mention one thing as it relates to a potential conspiracy claim. My client, as we've already been discussing, was the insurance agent for this Sanchez Enterprise Group for several years. It's been the same policy the whole time. And what was requested at the time was just a certificate evidencing what the policy had been and continued to be for Mr. Sanchez and what he had requested. And my client was never under any other understanding and never was requested to provide any additional or supplemental coverage at any point. So I don't know that they're going to ever find that information, but if you would like the order to read that if that information ever comes to light, then they can come back and file an amended statement of claims. I'll put that in the order.
Well, I do think, sir, that it would be very beneficial to Alpha Omega that if you had communications that would prove that your client was not in cahoots with Sanchez and that you gave him the policy that he specifically requested and nothing else, that information be shared, because the crux of their claim is that your client knew that there was more liability insurance that was required and disregarded it and made it look like Sanchez had it when they didn't. And although I'm saying it's a stretch today, that's what they're looking at. And anything that you could do to convince them that that is not a true statement would be beneficial to your client. Because in all honesty, if they come up with information that shows to them, and I'm even a little bit of information, that Sanchez and your client was conspiring to defraud the condo complex that they live in, I'm going to allow them to amend the complaint. When I say I'm dismissing it, dismissed without prejudice means it can be readdressed by the court if you can find some evidence to prove it. So it doesn't mean that I'm throwing your claim out. It means that I don't think your claim is ripe for determination right now because I don't find that there is sufficient evidence of the conspiracy or of the fraud. That doesn't mean that you won't find it. You just don't have it today, folks.
Your Honor, can we want to have discovery on Alpha Omega, so we'd like to serve interrogatories. I'm concerned that if they're not a party, they won't respond to these. So is there something you can put in the order that we're permitted to continue with discovery against Alpha Omega?
I'll let you.
Or just give us the application.
You have two options when they're no longer a party. Now, option number one is you can file a third-party request to produce to them because they're no longer a party. You still always have the option to take a deposition. I think I left open.
Only if they're going to be a witness.
And we don't want to change that.
Each party may depose any witness that an adverse party intends to call for up to 1 hour. I'm going to change this order because I am going, even though I am granting the motion to dismiss, I am going to allow them to depose the Alpha Omega representative.
Your Honor, we're not going to take depositions, so that's fine.
So we don't need to change that because this is a small claims case.
Okay.
We're not going to take any depositions. We might
Well,
ask them.
you can still do a third-party request to produce, even though they're not a party. You can't do interrogatories when they're not a party, but you're looking for documents. You can always subpoena documents from them, which they may be willing to give you without a third-party request because they don't want to be a part of this litigation and they're saying that they didn't have anything to do with it. So as I said before, it might be beneficial, and this is a small claims case, and what we always hope in a small claims case where the numbers aren't big is that everybody kind of cooperates with each other so we can, number one, find out who the true parties and interests are, and number two, bring the case to conclusion expeditiously. One of the reasons why I limited the discovery is that I just didn't want to see this become.
Your Honor, that's all good.
Yes, sir. I just didn't want to see it become like one of my civil cases where everybody's doing all this discovery and everything, and this thing that you're seeking to recoup ends up costing more in fees and costs than it's worth, and then that defeats the purpose of having small claims.
I think the order as written is fine, and we'll ask Mr. Zoloff if he can get us a copy of the application for insurance, and then maybe the thing will go away with respect to Alpha Omega.
Right, and the other thing is that you would expect that the defendant Sanchez group would have that same information. I mean, if they were working together on this, you would think they would have the same information, but maybe not. Maybe one has it and the other doesn't. But there is a remedy there for you folks. But at this time, I am going to grant the motion without prejudice. If you can provide me with an order, Mr. Zolot, please.
I'll circulate one to Mr. Feldman for his review prior to submitting.
Take a look at this. And then it does say that we're set for a pretrial on March the 5th. That was set on, let's see, when did we do that?
Well, is that a pretrial or is that the?
That's a pretrial.
Yeah.
With just the Mendelsohn Martinez defendants.
Mm-hmm. And I don't remember if I scheduled that for a judicial pretrial or if that was one with the mediation. It doesn't say in my notes.
I believe it's supposed to be the mediation.
I think it is too. Let me just look on my calendar and make sure it's not sitting on my calendar. March 5th at 10:30. Because I think I set some others that day because it was going to be a mediation date. Yep, I don't have it. So hopefully by that time, you guys will have enough information that you can at least have some good conversations about whether there's a possible resolution of your matter for you. Okay.
Okay.
All right. Thank you, everybody.
Thank you very much.
Thank
Have
you.
a good day. All right. Bye.
Do you know how
All
to
right.
leave?
What happened to my other one? Natalia, I don't know what happened to my second hearing. Let me just take a look. Ah, these no-shows are killing me. Oh. I don't even see a notice of hearing on here. Oh, wait.
Hey there.
Hi. So I don't have anybody over Zoom on ceramic installation versus blue water.
Okay.
It's like, and there's no notice of cancellation, and it's 2 o'clock.
Yep, it was at 1:30, 5 minutes. Notice of hearing via Zoom. They were instructed to call me, and I have their emails, and I sent the Zoom information out to all the attorneys, and no one has canceled.
Would you just please call them and ask them to please just call you in the morning as a courtesy to cancel? They don't, I mean, if they're not going to go forward with it, it would just be super helpful to me because then I prepare and look through the file and, you know, and then they just don't even have the courtesy of letting us know that we're not going forward. It's
Yeah, well, I'm going to email them right now.
a little bit rude.
Well, what is that?
It's rude.
No, that's for January 26th.
No, this is a motion.
I'm going to,
Motion to
send
show
them an email
cause.
right now.
Yeah, just, you know, we just appreciate a courtesy call if they're not going to appear today. Just call us in the morning and say, hey, you know, I'm not going to be here. We worked it out or whatever, and then we can just take it off, and then I don't spend the morning pouring through their file, and then sit here and go, where are they? I just, you know.
Right, because this has been set since December.
Right.
No, I'm gonna email them right now.
So it's just kind of common courtesy.
Thank you.
Thank you.
Okay, bye.
Okay, bye. Oh, shoot, I forgot to ask her if I'm in this courtroom tomorrow. All right, Natalia, I think that's everything for today. I'll see you tomorrow, maybe? Are you on here for tomorrow too? Yes? Yes? Nope, I can't hear you. But you're here tomorrow. I'm actually going to ask Jen to call them today to see if they've worked it out because I was hoping that maybe they might have come up with some agreements, but I don't know. We'll see. If so, I'll let you know. Yeah, I can hear you.
Okay, good. Okay.
Yep.
Okay, I'll see you
So-
tomorrow then.
All right, see you tomorrow. Have
See
a good
ya.
night.
Bye-bye.
Bye.
Thank you.
Thank you.